Okay.
And then, who else do we have?
Clayton Collins.
He's up here as well.
He's here now.
Okay, we are ready to go, whichever case you want.
Let's see. We have the red facilities.
Blankenship, that's Miss Hapner's, and Wilkes is in jail. Edward Ferris is in rehab, and
Okay, we'll call it State versus Blankenship, temporary Blankenship. Just had her on, not seen your video.
Oh, there we are. Sorry about that. Yeah.
on the record
By the
blanket.
way, the other day when you couldn't see me, turned out that there's a cover on my camera that I didn't know about. Top, and apparently when I opened and closed my laptop, I slid the cover over the camera. I've got two other laptops, one at home and one in the office, neither one of them has a cover. So.
Yeah, mine doesn't either. That's interesting.
All right. And you're Amber Ray Blankenship?
Yes.
All right. This is the case number 21 CR 81, State of Ohio versus Amber Ray Blankenship. This hearing is being conducted by Zoom. Ms. Blankenship is in a treatment facility, and this afternoon, your client are both consenting to this matter being conducted by remote virtual only instead of in-person presence.
We are, Your Honor.
You're all right, Ms. Blankenship?
Yes.
All right, thank you. All right, Ms. Blankenship entered plead guilty to aggravated possession of a fentanyl-related compound, fifth-degree felony, in court order of a pre-sentence report. I have received that, and also Mr. Blankenship has been screening for admission to the drug court docket, and so. Circle is recommended that she be accepted. I'm sure you file an application for drug court. This, oh yeah, here it is. I found this line too. Yeah, actually, it's filed at the time of the plea. All right. All right, Ms. Collins, on behalf of the state.
I only must consent within the plea agreement.
All right, Ms. Hapner.
Thank you, Your Honor. We would ask that Amber be accepted to drug court. She has, my understanding is at this point she has completed St. Lucie and she's in the aftercare program. So I think she's making great progress on being where she needs to be. And that having the drug court would be good for her. She is, as I think we're all aware, has had various issues over the years. And she'll get clean. And then sometimes I think this was a relapse. So if we have the drug court, I think that will help her on a long-term basis and will benefit everybody. So we would ask that she be admitted to drug court and bring community control.
All right, Ms. Blankenship, anything you would like to say?
Today I hit my 6-month mark of being clean. This program has really helped me out this time, and I'm doing everything different than what I would have last time. I'm attending meetings, I have a sponsor, I'm still in transitional living, I now have a job, and these are all things that I've never done before. And I just really hope that I get drug court, that way I can have the extra accountability also, and along with the program, I have rules and stuff that I need to follow also. So.
All right. Well, Ms. Blankenship, I know that we went over this with Mr. Sturgill, but under the way the drug court works is it is something that you have to request. You know, I don't order people to do drug court because it's a bigger commitment. It's actually we ask for a commitment on when we put people in community control, and you know you've been there. you know, we basically are saying, here's the things you need to do to stay out of prison. And, you know, they include treatment and so forth, but, you know, we don't ask you to make a commitment, other than, you know, it's up to you. Do what you're supposed to do, and, you know, you fail to do that, pass it, you know, some consequences. So drug court will be much more intensive, and I know you were here the other day to observe how that works, in hearings. And there'll be much more intensive programming. You've already gone a long way in that, but we'll also be intensive testing. Again, congratulations, by the way, on 6 months of that's good.
Thank you.
And so, you know, that's something that you know, people have to request. So you haven't requested that, and it's been, you know, a while. Are you? That's still what you want to do.
Yes.
Okay. Well, then if you order the court, that should be accepted into the drug court docket, and the court hereby orders that you be placed on 3 years of community control supervision in the drug court docket program. And you have gone over those, I know we have your signed acknowledgement of that in the file, but I'm going to just kind of highlight some of those things. First of all, you'll be required to obey all laws, all jurisdictions, conduct yourself with all body and manner on time. You must report what you've been directed. You must be truthful in all statements that you make to them or answers you give to the questions they ask you about your conditions of big control as well as your treatment. You'll be required to keep them informed of your residence, place of employment at all times, not to change either without prior permission. You cannot leave the state of Ohio at any time without prior written permission, and if you do, you have to have that with you when you're out of state. You may not enter upon the grounds of any correctional facility of any jurisdiction, or nor may you communicate with anyone who's inmate any of those without prior written permission. Now, you have some convictions in the past, but this one also disqualifies you under both federal and state law. Possessing, using, or having, purchasing any firearm, ammunition, or dangerous ordnance. It's also a condition that you not have those during your time on community control, or any other weapons of any other type. You're not permitted to purchase, possess, use, have under control any kind of controlled substance, any drug abuse, any CBD oil, traders, or any kind of a variant or analog of a controlled substance drug abuse. There's a lot of them out there now that are being changed that mimic or give similar effects to those kind of things. So you're not permitted to have any of those. You're not, unless you have a lawful restriction. If you do, you must provide a copy of that to your probation officer when that occurs. You must, and you have to do that within 24 hours. You must submit to drug testing when it has correct. You're not permitted while you're in drug court office to obtain medical marijuana. I know that that's popular now, but again, treatment, any kind of self-medicating things interfere with recovery, so you may not have any of those. And also, you may not purchase, use, or in any way, any kind of alcoholic beverage for the same reason. Or may you play present places where your soul will be consumed, even if that is otherwise lawful. You must submit to drug testing when it is requested by either probation or your treatment team. You may not associate with anyone who's a co-defendant case or anyone who has a criminal record, member of the gang, or other person who has the past could be influenced to commit criminal offense by these conditions, unless approved in writing by your supervising officer. Now, obviously, that doesn't apply to groups and that kind of thing, but you can't have out of treatment relationship with a person like that unless you get permission from the probation officer. Because again, those people's situations have triggers and relapses that need to be avoided.
Okay.
You may not act in data disorder, bury or establish cohabitation, alcohol marriage type relationship with another without written permission. You must report any time you come in contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurred. You must provide your financial information records to your supervising officer so they can determine your ability to pay fees or costs. If you're referred by either the probation department or any other treatment between a team provider or any evaluation assessment for further programming, treatment, counseling, etc. You are submitted to that. If there's a recommendation for additional programming, you're to enroll in and successfully complete that. You're to pay the court costs of this action and make payment arrangements to do that with the clerk. And then you're required to comply with all the conditions of the drug court program that have been provided to you and incorporated in here. Those are the conditions of the program descriptions and so on. Those are incorporated, all those incorporated, these I didn't mention here specifically today. And you must comply with your treatment plan. Again, whatever they tell you to do, that's what you need to do. Now, by being placed on community control rather than being sentenced to prison, you're deemed to be consented to a search without a warrant of your person, your residence, vehicles, Illinois, you or any other property place or your county under your control at any time, any officer of the probation department. There will be no fine, there will be no driving suspension. Now, in an event that you fail to pay your court costs, the court will do community service. Give you credit and hourly court for each hour work. Each hour work will reduce the judgment by that full. Now, in the event that the probation department or the treatment team indications that have been compliant, the probation department will file a written notice of that report and serve you a copy. There will be a hearing. In the event that it is determined that you failed to comply, then at that time the court determines you to the drug court office, revoke your control, and send you to prison for between 6 to 12 months and fine you $2,500. If that happens, then once you complete that prison term, it's possible under the law that you may be put under close police control supervision by the APA for a period of about 3 years. If that occurs, they determine that you have failed to comply with any of those conditions. They can return you to prison even though you serve the entire term set by the court. An additional period of up to half of your prison term is one or more violations, but you get a new felony, and in addition to every sentence the judge in the new felony case imposed upon you, the judge could also sentence you in this case to an additional period of 1 year, where it's not on that year, post police control term is greater. If that occurs, that has to serve secondly to the sentence in the case. All right, is there anything further from counsel?
No, Your Honor.
All right, you're now terminated from pretrial supervision, so those conditions no longer apply. You will need to make contact with the probation department. Ms. Sturgill, she called in, or do you have an appointment scheduled for her yet? You're unmuted.
Yes, sir, we've been talking, we're in contact.
Okay, all right. So just under the new conditions now, previous ones, pretrial supervision are gone. All right, good luck. We'll look forward to seeing you next Wednesday. All right.
All right, thank you.
All right. Nate versus James Welch. Is that you, Mr. Welch? There. Both that you,
Sir. Hear me now?
Yeah, I can hear you now. All right. Let's see. Ms. Carter is your attorney. All right.
1 second, Your Honor. Scroll through. On the record.
All right. This is case number 21 CR 99, State of Ohio versus James Edgar Welch Jr. This hearing is being conducted by Zoom, and Mr. Welch, that's you on the street, Mark James W. Okay, you need to maybe lean in a little closer or speak up a little. I'm having just a little trouble hearing you.
Yes, sir.
Okay, and you're at the treatment facility, is that right, Mr. Welch?
Yes, sir.
Okay, at Woodhaven, all right. All right, Mr. Welch's attorney, Sarah Barber, and the estate's represented by prosecutor Collins. This hearing is being conducted by Zoom. Barber, you and your client both consent to have this hearing remotely or virtually rather than in person.
Sure, Honor.
And Mr. Welch, you agree with that?
Yes, sir.
Okay. All right. The defendant entered a plea of guilty to possession of heroin and also aggravated possession of methamphetamine, 2 fifth-degree felonies. The matter was referred to the probation department for a pre-sentence report, and the court has received that and reviewed the sentence. And did indicate that he is at Woodhaven residential treatment and Dayton. All right. Anything from the state regarding sentencing?
Only what's contained within the plea agreement.
All right, Ms. Barber?
Just what's contained within the plea agreement, Your Honor.
You guys must all have appointments somewhere, like being really church this morning. All right, Mr. Welch, anything you would like to say?
I'm glad I came here. I just never thought in a million years I'd be able to get away from the drugs, you know. But I feel good. My head, my thinking's more, you know, straightforward, clear. You know, I feel good today.
Okay, you've been there since the 20th?
Yeah.
Okay. All right. Anything else you'd like to say?
No, sir.
All right. Well, it is the order of the court that you be placed on 3 years of community service, community control, as your sentence. And that will be under the supervision of the probation department, and you must comply with these conditions. First, you obey all laws, all jurisdictions, protect yourself, qualified, manner, all five. Court will as directed, be truthful in all statements you make, as well as any answers you give to questions to the probation department or treatment provider. You must keep your supervising officer informed of the residence, place, and local on time, and change items without prior permission. Not leave the state of Ohio at any time without prior written permission. Now, enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who is an inmate into the facility without prior written permission. You may not purchase, possess, use, or have under your control any kind of a firearm, ammunition, dangerous ordnance, or weapons of any other type. And if you possess, purchase, use, or obtain firearms or ammunition, dangerous ordnance, you can be prosecuted under both federal, state law, and felony. Those are conditions of control as well. You're not permitted to purchase, possess, use, have under your control any kind of controlled substance, drug abuse, CBD, oil, creation, or any other very any controlled substance that has effects similar to those controlled substances and drug abuse. You may not have under your control or purchase or use any instrument, device, or thing that may be used to administer any of those items without a prior lawful prescription for both the substance and the device. You must provide a copy of that so far as received to your supervising officer. Your dismissed drug testing when and as directed. You may not purchase, possess, use, have under control any alcoholic beverage or may be present in any places where it's sold or being consumed, even as otherwise lawful. Not associated with anyone as a co-defendant in this case or any other person that has a criminal record, member of a gang or a criminal group, or any other person that has a past with the criminal offense violating these conditions unless approved in writing by your supervising officer. It also applies to any family members who fall within that definition, unless you were living with them immediately before commission of these offenses. You may not act at the date of this order, marriage established cohabitation, and common law marriage relationship with another person after the commission. Must report any conviction, arrest, citation, or other charge violating the law not like the master's exam that occurs. You must provide your supervising officer with financial information records so that your board can be properly reviewed. If you're referred for evaluation, assessment, any further treatment, counseling, training, education programming, etc., you're by probation, you're dismissed that with any programming recommended unless the rule limits successful to that. You pay the court costs of this action, make payments for arrangement with the court. You also do 4 hours a week service, every 20 hours a week, 20 consecutive weeks, unless you're employed at least 20 hours a week, 2 times a week, or you have documentation from a position of prior disability from you unable to do that. You must also, as a special condition, successfully complete residential substance use disorder treatment and Woodhaven and any recommended care. By being placed on community control rather than being sentenced to prison, you're deemed consented to a search without a warrant of your person, residence, business, no way you, abused by you, any other property places under your control where you're found at any time, any officer of the probation department. Be no fine or driving suspension imposed. You're also to pay the court costs as a substance order. If you don't make payment arrangements, don't pay your costs. The court could already do additional fees beyond that already ordered. That would be, you would give credit for each hour you work in an hourly rate set by the court. Each hour you work, you give producer judgment by the amount of pay full. Now, in the event that you're alleged to have violated these conditions, probation will file written notice of that court, provide your copy, and we have to have a hearing, be represented by an attorney, and the outcome of that hearing is that you fail to comply. At that time, the court could sentence you to prison for 24 months, fining $5,000. If that occurs, once you complete that prison term imposed by the court, the court has the option, if they choose to use it, to shut post control for a period of up to 3 years. You do be supervised in the terms they set, and during that period of time, they find that you are not compliant. They can return you to prison if you serve an additional period of up to 9 months in one violation of the maximum half of whatever prison term is imposed by the court for all violations. But if violations do felony, then in addition, whatever sentence the judge in the new case imposed upon you, that judge would also sentence you for committing that offense while under pushing his control. In this case, the additional period of 1 year, whatever time left on that period of post control is greater. That occurred, that would be served consecutively the sentence in the case. All right, is there anything further with counsel?
Your Honor.
All right. Now, Mr. Welch, you're off of pretrial supervision. Just need to stay in touch with the probation department so that they're aware of what's going on. So if you get done sometime today and get a chance, you can give them a call.
Yeah, they only let us have it. I'll have to give a caseworker and set that up.
Okay. All right. Thank you. You can go ahead and log off then.
Thank you.
All right. Let's see.
Have Mr. Ferris in rehab.
Okay, Mr. Ferris, is that you on the phone that says Christian? Or on the screen says Christian?
Yes, sir.
All right.
Ms. Hapner.
And Edward Ferris. State of Ohio versus Edward Dean Ferris, 21 CR 95. Mr. Ferris is appearing by video from treatment facility. Let's see, where are you at?
United Family Recovery, sir.
Okay.
Ironton, Ohio.
Ironton, okay. All right. And his attorney is Captain Hapner, and representing the state is Adam King, assistant prosecutor. Hearing being conducted by Zoom, all persons are present by Zoom. And Ms. Hapner, you and your client both waiving personal presence and setting this hearing being conducted virtually.
Yes, Your Honor.
You're okay with that, Mr. Ferris?
Yes, Your Honor.
All right. Mr. Ferris was convicted of retaliation by plea, a third-degree felony. The court ordered a pre-sentence report, and I have reviewed that. And this time I'll ask if the state has anything you'd like to say regarding the disposition of this case.
Only what is contained in the plea agreement, Your Honor.
And I probably asked this at the time of the plea, but the state didn't consent or consult with the victim and agree with this disposition.
We actually weren't able to make contact with him, Your Honor.
Okay. All right, well, I'm familiar with you from the trial, so I'll understand.
Correct.
All right. Ms. Hapner?
Thank you, Your Honor. We would ask that you follow the agreement and place Mr. Ferris on community control. He has been doing well in his treatment facility. It's my understanding that he intends to remain there to complete his program. I don't believe that there'll be any further issues with him, as I think this was isolated to one particular case, and that case has been disposed of. And I think he has learned from this and grown, and that we won't have any further issues, and that community control is an appropriate resolution in this case.
All right, thank you. Mr. Ferris, anything you'd like to say?
Yes, Your Honor. This treatment facility here has helped me come a long way. I never thought I would get off drugs, and what drugs did to me, my mindset, the way I was thinking, and everything else. And now I can think more clear and got structure in my life for this, and I couldn't ask for better people to help me through what I've been through all my life. And that's all I gotta say, Your Honor.
Mr. Ferris, let me tell you, I'm really concerned about the offense here. retaliation. And the reason that's such a serious matter in my mind is because it goes to, strikes the very heart of the justice system. You know, the conviction is for retaliating against a witness who is doing what they were required by law to do, to come to court and testify. And I know that trial, there was a lot of stuff that was thrown out there by the defendant that was totally rejected as having no credibility whatsoever by the jury. And things that you said on Facebook were extremely serious. Quite honestly, when I took the plea, I thought that it would be more likely than not that I was sent to prison despite the recommendation, because I just consider witness, any offense that occurs against a witness, in my mind, is extremely serious and cannot be tolerated. And that's a problem for me. And here's the other thing that I'm going to quote from the pre-sentence report. Your statement that you gave in writing to the probation officer says, I recognize now that sending Jacob a threatening message was wrong, but at the time I believed I was defending Brittany's reputation. Now, how does that make sense? You defend somebody's reputation by committing a crime? That's like saying, well, you know, I thought I defended the person's reputation by killing the person who said bad things about it. You know, you can't commit a crime to defend somebody's reputation, particularly that person when your judgment was so bad about what you thought. So what that statement says to me doesn't seem to be that your drug issue had a lot to do with that. And so I'm hoping that you're getting mental health treatment with that program, because it tells me that you have some real issues about understanding what's right and wrong. The other thing about it is that social media has become such a, well, quite honestly, it's a way of domestic terrorism. People just go after each other on social media with abandon, and because they can hide. They don't have to be in front of the person and say it. They can say anything they want at any time, and most of the time it has very little accuracy. Sometimes it's outright lies, other times it's just ignorance. Why I think people say that they can go and say things like that they normally wouldn't say to somebody's face or in the presence of other people. I don't get that. And I'm an old cocker and I don't do social media. But I can see what's going on in the world today. And, it's filtering down now into cases like this. So, I'm giving you that to give you fair warning. I'm going to go ahead and put you on complete control. But I'm going to tell you right now, I'm not a big fan of it because of your offense, but because you have gone into treatment, you are doing well, and you seem to truly be trying. And I mean, part of that I'm sure is to stay out of prison, but I hope that it's more than that it's, a true recognition of the issues you have that you're going to deal with. But I can say, don't expect a lot of leeway. You get, if you violate any of these conditions that I'm going to tell you here in a moment, when we come back here, you're probably going to go to prison for the first violation. Because I can tell you again, my impression when I took this plea was this is a prison sentence offense. And, that's just the way it is. So you're getting a break here. Best statement.
Thank you, Your Honor.
Because if you come back in here and say, I want a second chance, that won't be your second chance, number one, it'll be a third. This is your second chance, but it's going to be your last one. So it's the order of the court that you be placed under sentence to a term of 3 years of community control under supervision of the probation department, and will be required to comply with all laws, all jurisdictions, conduct yourself in all binding manner at all times. You must report when and directed, be truthful in all statements you make, as well as any answers you give to the probation department regarding questions they ask you about your condition. Plus, keep them informed of your residence and place of employment at all times. May not change either without prior permission. Now, leave the state of Ohio without prior written permission. May not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who is an inmate in the facility without prior permission. You may not purchase, possess, use, or have under control any firearm, ammunition, dangerous orders, or weapon of any other type. May not purchase, possess, use, or have under control any kind of controlled substance, drug abuse, CBD oil, kratom, or any other varying analog that might have in fact similar controlled substance drug use, or any other device, instrument they can use to administer or help to administer those. Prepare that administration unless you have a lawful prescription, and you must provide that copy of that to your probation officer within 24 hours. You must submit to drug testing when and as directed by probation. May not purchase, possess, use, or have under control any alcoholic beverage, nor be present places with the soul being consumed, even so otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any other person in a criminal record, a member of a gang, or a criminal group, or any other person has a past or good future, unless you commit a criminal offense violating these conditions, unless that's approved in writing by a supervised officer. And that would also apply to any persons that or any family members involved in that definition, unless you're looking for that needed for commission of this offense. After the date of this order, you're not to marry or establish cohabitation or follow a marriage-type relationship with another person without written permission. Must report again, contact law enforcement or arrest citation, conviction, or other charge violating the law not later than next business day after that occurs. You must provide your supervised officer financial information records so your ability to pay any fees costs will be reviewed. If you're referred by probation for any additional evaluation, assessment, any kind of treatment, therapy, programming of any kind, you submit to that. If they recommend any programming, your role is exception to do that. Pay the court costs of this action, and make payment arrangements to do so. Perform 400 hours of community service at the rate of 20 hours per week or 20 consecutive weeks, unless you're employed at least 20 hours per week, full-time student, or documented by a physician or disability line, the ability to do that work. While you're in your treatment facility, you don't have to do that. That'll be done afterwards. You're also to successfully complete the United Health Recovery Treatment Program and aftercare. You're not to have any contact with David Perkins or Brittany Haynes of any kind. Now, by being placed on community control, you're deemed to consent to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other property place that is owned by you or under your control, or where you're at any time, any officer of the probation department. Now, in the event that, you're also going to pay the court costs, and if you fail to do that in court, only you can do additional community service beyond that already ordered as an addition, and give you credit for each hour you work, and earn the rest of the court each hour you work, reduce your judge by that amount, pay full. That community service have done in this county. Now, if you fail to pay those costs, in addition to being a violation of your community control conditions, the court clerk also applied that to various means, in addition to by levy on any bank calculations or other things. Now, in the event that it's alleged that you have failed to comply with this sentence, these conditions in this sentence, then the probation department will file a notice of that to the court. You'll be given a written copy of that. There will be a hearing, and if the outcome of that hearing is that you have failed to comply, at that time you'll be sentenced actually, is it 110 effective today or September 30th, Ms. Collins?
September 30th.
Okay. All right, so you'd be sentenced to a term of 36 months and fined $10,000. If that happens, once you complete the sentence imposed by the court, the adult parole authority may, at their option, choose to put you in post-release control for a period of up to 3 years. They do, you'll be supervised on the terms they set. They determine that you fail to comply, they can return you to prison, they can serve additional period of up to 9 months for one violation up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new felony case can impose upon you, the judge will also authorize the sentence in this case to an additional period of 1 year or whatever time is left on the 3 year post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right, Mr. Parrish, you're no longer under pretrial supervision conditions. You're under the new conditions. Contact the probation office by phone today so they can get you in touch with your new probation officer to be a different officer than what you had. Do you have any questions?
No, sir. Thank you very much, Your Honor.
All right. Thank you.
Have Arnett.
Let's see. Who's there on the screen marked iPhone?
Madeline Arnett. I'm sorry, I'm at work, Your Honor.
No problem, all right? State versus Madeline Arnett, 20 CR 216.
On the
Okay,
record.
case number 20 CR 216 State of Ohio versus Madeline Arnett. Arnett is appearing on by Zoom on the screen mark iPhone. Her attorney is Kathy Hackner, and her name state is Anna Collins. The hearing being conducted by Zoom remotely, and Ms. Hackner, your client agreed to conduct this remotely rather than in person.
Yes, Your Honor.
You all right with that, Ms. Arnett?
Yes.
All right. I set this hearing because we had a hearing last week, and I received information from the base office through my sign commissioner that there's some issues going on, and that Ms. Arnett was pretty upset with the situation, and I think that maybe we've been some discussion of that before. And so the reason I said this, Ms. Arnett, was to see if you felt this you would just have to still work together, or if you would like another attorney.
Your Honor, honestly, I would like a new attorney.
That's all I need to know. That's all I need.
Okay.
Ms. Hackner, you.
That's fine, Your
All
Honor.
right. Well, then the court will appoint new counsel for Ms. Arnett. I'll appoint attorney James Wagner. He's on the screen there. And Ms. Hackner, if you would get your file to him within the next, by the end of the week, please. And,
Yes, no problem, Your Honor.
all right, and then you have a trial date, I think, set for the 23rd, is that correct?
20th,
20th?
yes.
Well, Mr. Wagner, since you're on there, I'm going to go ahead and vacate the trial date due to new counsel. I assume he wants more than 3 weeks to work with this case.
If I may, sir.
All right. So what I'll do is I'll set a pretrial for September 22nd at 2:15. Do that by Zoom. And then the new trial will be October 14th at 8 a.m. So you can contact the clerk's office and get Mr. Wagner's number. His office is right next to the armory, across the street from UDF. So you can stop at his office and make an appointment to get a hold of him. Meet with him.
All right, thank you.
All right, thank you. All right, let's see.
To jail.
Okay, what's your name there in the jail, sir?
Seth Wills.
Seth Wills, all right. I have 2 cases here. Both styles, State of Ohio versus Seth Wilkes. 20 CR 261 and 21 CR 92. Mr. Wilkes is appearing by Zoom from the jail. And let's see. Mr. Wagner, you representing Mr. Wilkes?
I am, sir.
Okay. We'll go ahead and my notes here. I don't want to excuse. All right, here we go. State's represented by prosecution attorney Collins. This hearing is being conducted by Zoom. And Mr. Wagner, you and your client both agree with this to be conducted virtually rather than in person.
Yeah, we spoke this morning, Your Honor.
And you're all right with that, Mr. Wilkes?
Yes, sir.
All right, in case number 21 CR 92, the defendant was convicted of a failure to appear by his plea in a court pre-filing. And in case number 20 CR 261, he was convicted of aggravated possession of setting. That's fifth pre-filing and failure to appear in a court pre-filing. The court referred the matter for a pre-sentence report. I have received that. Also, he was screened by the drug court, and this circle was found to meet the criteria for to that. There are some complicated issues, so address those here more. But for the time being, anything from the state regarding the sentencing?
Yes, Your Honor, we would ask the court to impose a term of incarceration in this case. We would note the defendant has 6 prior felony convictions. He currently has an F5 possession of drugs charge pending in Claremont County. He has a warrant from Brown County Municipal Court for an F5 breaking and entering and an M1 theft. He has a warrant out of Clinton County Municipal Court, and he has a warrant out of Hillsborough Municipal Court. Our initial recommendation for the defendant was drug court with community control with drug court. However, it's obvious based on the fact that he failed to appear that he isn't really interested in getting help with his addiction. He's really just interested in not going to prison. He is obviously not amenable to community control if he couldn't even comply with the terms and conditions of this court's pretrial supervision. And based on all of that, I would ask the court to sentence the defendant to a term of incarceration. Thank you.
Wagner?
Your Honor, I would agree with some of the things Ms. Collins indicated. The sad thing is I've met with Seth numerous times. His original offer in this was drug court. That being an offer from the state, even though they knew his current criminal record. We can't get around the fact he has these new charges. Seth and I kind of had a heart-to-heart is he had a golden opportunity here and he relapsed, started using again, got spooked, took off, Your Honor. That's where the failure to appear came. I guess I'm reaching out to the court at one time. The state and myself thought he was worth taking a flyer on for drug court or some kind of treatment. He shouldn't benefit from failing to appear. We get that. But I also feel if at one point we thought this guy was worth a chance, I still think he's worth the chance. Be it drug court, some residential treatment. People, the comments made often, you're only doing this to stay out of prison. No one wants to go to prison. If they do, they got a serious problem. But I think Seth's worth the risk, Your Honor. If he messes up, then he'll suffer the consequences. We're simply asking the court to take that one risk.
All right, Mr. Wilson, anything you'd like to say?
Yes, I was offered the drug court in the first thing, and I was on the pretrial supervision. I was doing good for a month or two, and I did relapse, as Jacob said, and that's where I was going to fail the drug test, so I got spooked and just never showed back up, and here I am. So I've heard good things about the drug court and the programs that you guys have, and I was just hoping that you would give me a chance. And that's it, Your Honor.
Well, the complicating factor here is all these other warrants that are out there. Have you been in court in Claremont County for the charge down there?
Yes, I've been to court one time. They LR'd me, and then I was in Claremont before I got here. And I only
Do you have any hearing schedule on that?
Yes, I have the first plea trial. I've had it set out twice. I've had my family contact Claremont, and it's set out for the 8th, a pretrial. So my lawyer down there knows that. Well, at that time, I thought I was getting the drug court, and they was hoping to maybe be able to run that F5 with the drug court. My probation officer was saying that she talked to the prosecutor or whatever, and I'm not 100% positive I have been there since I've been here. But that's just what my mother and the lawyer was saying.
And you've not been in Brown County on the warrant there?
No. I heard I guess it's a misdemeanor theft.
It's the felony B&E.
Yes, felony. Is what I got in the report here.
Right. Yeah, I haven't been there.
Well, Mr. Wilson, we're just this court we're dealing with.
I know.
Mr. Wilkes, don't talk anymore.
I'm sorry.
For just this court cases, I feel more inclined to push into the drug court program, but the problem is, you got these other cases pending, and nobody knows what's going to happen there. And there's a warrant out, and actually there's also a warrant out about Clinton County. And so, with that in mind, it's going to be more difficult to start really take you as the hold on you. And that was the recommendation, is to start that available on the 15th of September, but I think that with these other warrants out there, those cases need to be cleared up before we get into this point of putting the drug.
Speak, Your Honor.
Go ahead.
Is there any way that I could somehow do like get a Zoom from here to their courts and try to
I can't answer that, so I have to talk to your attorney on that.
Okay.
And then you have to find, and you don't apparently have an attorney in Brown County yet because they haven't served the warrant out this court. And so that's just that's a mind over stage.
Can I say one thing, sir?
Yes.
All of my charges, if you've seen my record, I know it's not good, and they all stem from a drug problem. So whether it's residential, whatever it may be, whatever if you decide, I would like to get some kind of rehab because I obviously need something.
Well, I'm looking here at your past. You've completed 2 programs in the past. One at the CCC in Lebanon in 16 to 17, and also River City in 18, both out of Cumberland County. Yeah, the problem is that I can't just turn you loose to go take care of those because I don't think you'll appear. Quite honestly, I think you go out and use drugs pretty quickly and then just get yourself in deep. And the other cases are nowhere near completion, so I can't set it aside for 2 weeks, 3 weeks, because he's been indicted in Brown County. And so with these pending cases, I don't think that it's appropriate at this point for me to give you complete control over the drug court. So it's the order of judgment of the court in case number 20 CR 261, the aggravated possession of amphetamine and 53 felony is to be sentenced to a term of 9 months correctional reception center in Warren, Ohio. And you'll get 64 days credit on that case. Case number 21 CR 92, failure to appear, be sentenced to a term of 12 months. There's no time for the sheriff on that. And those sentences would be ordered to be served consecutively to each other, and the court finds that second sentences are appropriate because 21 CR 92 was committed while you were awaiting trial, 20 CR 261. The case number committed as part of 2 or more courses of conduct, and 1 single prison term not adequately reflect the seriousness of the offense. And your history is already below that subject district criminal conduct demonstrates that the second sentence is necessary to protect the public. Now, upon completion of that sentence, the adult parole authority may choose to issue under post-release control for a period of up to 3 years. It's up to them. The court has no involvement with that. If they decide to do that, then if we supervise in the terms they set by a parole officer, during that period of time, they determine that you fail to comply, they can return you to prison, making certain additional period of up to 9 months for one violation up to a maximum of half the prison term for all violations. But if you commit a felony, then additional represents the judge in due case of both, when that judge is also authorized to sentence you. In this case, to an additional period, 1 year or whatever time left on the period of post-release control, whichever is greater, that occurs, that must be served consecutively and sentenced in the case. Also, we're paid court costs, which doesn't speak for order, to be able to do that. The clerk collects that through various means, including levies, bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the sentence, you may do community service in this county, and you can get credit for each hour you work in an hour where set in the court, each hour you work, or reduce your judgment by that amount until paid in full. All right, now, Mr. Wilkes, once you get those other cases taken care of, after you've been in 6 months, and you can file for judicial release, and if those courts are willing to work with you on that, then I will look at judicial release pretty favorably. And I'm not promising you anything. I'm just telling you that, if you get those other 2 worked out, where that's possible, then at that time the court would probably grant you judicial release in Star and then in the drug court. But, again, we'll have to see what your situation is when you file that. All right, anything further from counsel?
No, Your Honor.
All right, thank you. Who's the other one we have here?
Morrison, Junior Morrison.
Is that James? Well,
Yes, Your Honor.
Case number 21 CR 104, State of Ohio versus Junior Lewis Morrison. Are you Junior Lewis Morrison? Currently there in the jail?
Yes.
All right. This hearing is being conducted by Zoom. Mr. Morrison, currently in the jail, his attorney, Jake Wagner, currently on Zoom as well. All right. Mr. Wagner, you and your client both agreed to appearances in this case virtually rather than in person.
We do, sir.
You're all right with that, Mr. Morrison?
Yes.
All right. Mr. Morrison has entered a plea of guilty to illegal advance of drugs use onto the ground of a specified governmental facility. Third-degree felony. The court referred the matter for a pre-sentence investigation. Received that report, and also he was screened for the drug court docket. But the problem that arises is that Mr. Morrison is a registered sex offender tier 2 and a Medicare recipient. Those are ineligible for the treatment programs that have MOUs with the drug court. So our recommendation is he be accepted in Turtle Creek, which does accept offenders with his background. And there's a bed available on some. All right. Right, or Ms. Collins, anything to say?
Only what's contained in the plea agreement, Your Honor.
Wagner?
Likewise, Your Honor, I went out and met with Junior this morning. Advised to him the drug court is probably not a possibility here today, but Turtle Creek had a bed. We would ask the court for a commitment to Turtle Creek, a rehab facility with community control, Your Honor.
All right, Mr. Morrison, anything you'd like to say?
I'd like for you to accept me to go to Turtle Creek because I've been accepted there. I want to change my life with my drug habit and stuff, and that's what got me here.
All right, so order the court that the defendant's request for admission in the drug court not be denied due to ineligibility for services from our provider and his status as a registered sex offender. But it is the order of the court, Mr. Morrison, that should be sentenced to a term of 3 years of community control supervision by the probation department. Under these conditions, first year pay all laws of all jurisdictions, conduct yourself in a law-abiding manner all the time, must report when and as directed, must be honest in all statements that you make to them, as well as any answers that you give to questions they ask you about your conditions. You are to keep them informed, or you may not leave the state of Ohio at any time without prior written permission, not change your residence or place of employment without prior permission. You may not purchase, possess, own, use, or have under control any controlled substance, any firearm, ammunition, dangerous ordnance, weapons of any other type. And to do so would be a violation of both federal and state laws, subject to you and prosecution for felonies if you did that. And you're not permitted to have those by law to control items. You're not permitted to purchase, possess, use, or have under control any kind of controlled substance, drug abuse, CBD, oil, trading, or any varying or analogous substance, controlled substance that affects similar to those of drugs and abuse, or any instrument, device, or thing that may be used to administer drugs and prepare them for use of administration unless you have a lawful prescription, and you must provide proof of that within 24 hours of receipt to your supervising officer. You're also to submit to drug testing when and as requested. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverage or be present in places where it's sold or being consumed with even otherwise lawful. You may not associate with anyone as a co-defendant or any person that has a criminal record, member of a gang, or a criminal group, or any person that has in the past or could in the future influence you to commit a criminal offense and violate these conditions unless that's approved in writing by your supervising officer. That also applies to any family members that fall within that definition unless you're living with them immediately prior to the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation with a law marriage type relationship with another person without written permission. Thus, report any contact to law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. Must provide your supervising officer financial information and records so your ability to pay any fees or costs will be reviewed. If you're referred for any other evaluation or assessment, any other type of treatment beyond that ordered by the court, by probation, then you'll submit to that. If any recommended programming will be required to enroll in and successfully complete that. You're required to pay the court costs and make payment arrangements to do that. You'll be required to successfully complete the Turtle Creek program and all aftercare. You'll remain in the jail until you can pay the Turtle Creek, which I think that will totally pay. Now, by being placed on community control rather than being sentenced to prison, you're deemed to be sentenced to a search without a warrant of your person, property, vehicles, or any other place where you're found, that is under your control at any time by any officer of the probation department. Now, no driving suspension issue or a fine. You fail to pay the court costs, it's also ordered the court that you must pay those, and if you do not pay those and make payment arrangements, then the court can order you to be service, give you credit for each hour you work, and are reset by the court. Each hour you work reduces that your judgment by that amount until it is paid in full. Now, in the event that it's alleged that you have failed to comply with this order, then the probation department will file a written notice of that with the court and give you a copy. You'll be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing is that you have failed to comply, then the court at that time can revoke your community control and then sentence you to 36 months in prison and fine you $10,000. If that happens, once you complete the sentence imposed by the court, it will be required that you be under 3 years of post-release control supervision by the adult parole board. And if they determine that you have failed to comply, they can return you to prison, make you serve an additional period, even though you serve the entire term set by the court, up to 9 months for one violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony offense, then in addition to whatever sentence the judge in the new case imposed upon you, the judge is also authorized to sentence you, in this case, to an additional period of 1 year whatever time's left on the period of post-release control, whichever is greater. If that occurs, that must be served consecutively sentence. All right, is there anything further from council?
Your Honor.
All right, you'll be held in jail until you go to terminal break. September 30th, they said was at the latest, maybe earlier than that, but you'll be in jail until you go there. All right, I believe I can please hold the Zoom hearing. So Ms. Collins, are you coming over, Mr. King?
We just got a Zoom invite for Tara Adams.
Tara Adams has been added to Zoom.
Oh, okay.
If she's logged in and she has Mr. Wagner.
Okay. All right, Mr. Wagner, Tara Adams. So that's a different Zoom. I'll have to log out then, I guess.
Yeah, it just came through.
Yeah, me too.
Is a separate invitation?
I think so. Yeah, it's a separate.
All right, because I can see her. She's not logged in here, so, okay.
Okay, we're ending Morrison.
Okay.
I'm going to go to
I don't have that.
Adams. Don't have a Zoom. Okay. We have two present in the courtroom, Your Honor, if you want to move on to those and come back to them, or do you want me to go get the address?
All right, Mr. Leitner. Okay, this is case number 21 CR 54. Ohio versus Austin Relay. Miss Adams was supposed to have a Zoom invite on her, but I don't have it. Was it on the old one or was it a new Zoom invite? Because they said it was a Zoom invite. Oh, okay, last week, because they thought it was right now. I think she said Sony.
Yep.
All right. And it didn't show up on my Zoom.
It was set for 10:15.
10:15, I get that. I still don't have it. All right. Is that prosecutor yet?
Here, I'll go to pause and wait.
Need to call the prosecutor, tell them to come over here. They thought that hearing right now. So, well, it said 10:15, we need the prosecutor over here now, so. Let's go back to LJD. He's waiting.
Oh, he's in there.
Your Honor, he has an investing case. You want to go ahead and do that or stick around here?
Yeah, you can go ahead and do that.
All right.
Because I don't have a Zoom invite. And somebody from the prosecutor's office has to go over for this one. Still not seeing a notice.
We're on the record, Leitner, Your Honor.
Case number 21 CR 54, State of Ohio versus Officer Leitner. Here on behalf of the state, Assistant Prosecutor Camp. Here on behalf of the defendant is Attorney Danny Alswick. Are you Officer Reed Leitner?
Yes, Your Honor.
Mr. Leitner is pleaded guilty to grand theft of firearms in a third-degree felony. The matter was referred for pre-sentence investigation. I received that. Did you proceed to summary?
Yes, Your Honor.
All right. Anything from the state?
Only was contained in the plea agreement, Your Honor.
And Ms. Whitten?
Yes, Your Honor. We ask the court for also to receive community control as well as treatment for his charges. It's no secret that he has had challenges throughout this case, and drugs has been the reason for that. And he has identified that with himself after speaking to him, and knows that treatment is really what he needs at this point in time.
Leitner? Anything you want to say?
When you gave me the opportunity to willingly seek help, I didn't abide by rules for the most part. I got the assessment done for this information, but I wanted to get myself clean before I went back, so I wouldn't have 30 tests sent to you. But I was unable to do so, and to pay rent to my grandmother, I do yard work around the house and everything to take care of my father. And I just kept getting more and more strung out. I do realize that I'm digging a deeper hole for myself and what I should be. I did another day of community service, but on top of her, after walking 8 hours, my legs was so tired that I just didn't feel like doing that again, honestly, but I know it needs to get done. I'm not holding anybody or trying to hold anybody accountable for my actions. I know I said some stupid stuff, and the thing that the packet thing that the probation department gave me to fill out for read, I just think that you can completely ignore those childish words and see to that I do want help, and I need to talk to my grandmother and my father and the people that are around me in my life to get on my ass or for my about actually getting this stuff done. That's all I have to say.
All right. Well, I received a report of probation yesterday. It said that you tested positive on 5/21 for meth, THC, marijuana, and amphetamines, 6/8/21 for THC, 8/17/21 for meth, amphetamines, and THC. And it said that you had contacted another chance, but you missed your appointment. I had a fax from them from yesterday afternoon that said that you went through an intake on the 9th, but did not in fact return the assessment on complete assessment on the 10th. Made arrangements to come in on 8:30. According to this, apparently you didn't go back on the 30th.
To another chance.
Yeah.
I called them and they told me to wait until Tom to get me called back.
No, wait a minute, no. Don't be giving me any crap here.
No,
I'm not going to put up with that. You know, you're not doing what you're told. I mean, you've been shotgun driving through this whole thing and just throwing off and blowing off something. And, you don't know how close you are to prison. You don't. Apparently you don't really think that that's going to happen. I can tell you that, if you don't turn around and start doing what you're told, it is going to happen. We're going to continue this sentencing. I want you to go to the probation department as soon as you leave here and make an appointment to be assessed for residential treatment. You're not taking the opportunity to go to another chance, and I've had to have it picked up a couple times, and at least you got that message, you're here. But it appears to me that you're not going to follow through on outpatient treatment, and it looks to me like the inpatient thing. So we'll continue this, and you go down to the probation immediately, and contact Ms. Sturgill, Ms. Adams about residential treatment, and sentencing will be referred to September 22nd at 9 a.m.
Your Honor, is there any way that we could move that to later in the day? I have another hearing scheduled at 9 o'clock.
Okay. I have pretrials in the afternoon, how about 11 a.m.?
Okay, that's fine.
All right, 11 a.m. Dale's going to give you an assignment notice. You'll be back here at 11 a.m. You'll wait for the probation department. You can see Ms. Sturgill or Ms. Adams about an assessment for residential treatment. All right. Go ahead and go right here, sign your assignment notice, and then head down to the probation. New Ohio versus Blake Collins.
Wait right here, Ken.
Contact Lonnie and tell her that Mr. Minor will assess for residential treatment. Cooperated with another thing. All right. Good. We might pull it up. Take it out. It's not on here. I'm not getting it. Not there.
Assignment notice.
They're in on the old. Oh. Yeah, I am the old one, not this up. Well, this Adams isn't on there. I'll call her and tell her to log in and then we'll wait. All right, go back and work on this case. Okay.
Back on the record for Collins.
All right, this is case number 21-0107, State of Ohio versus Clayton Tyler Collins, present for the state, is the assistant prosecutor, Adam King, present for the defendant, is Daniel Witt. Are you Clayton Tyler Collins?
Yes, Your Honor.
Collins entered the plea of guilty to failure to comply with order signal police officer third-degree felony. Court ordered a pre-sentence report. I have reviewed that. Have each of the attorneys received a summary?
They have one.
Yes, Your Honor.
Right. Anything from the state regarding sentencing?
Only let Daniel please hear me, Your Honor.
All for this witness?
Yes, Your Honor. This is Clayton's first felony. He, at the time of the incident, was, as you can tell from the facts of the case, very high. So drugs are the root of Clayton's felony charge. He has been accepted to STAR, so we just asked the court to sentence him to STAR in community control.
Collins?
Your Honor, honestly, drugs have been a really big issue in my life here recently. I'm tired of being in the court system, tired of being in the probation system. I'm ready to turn my life around. I think STAR would be a great opportunity to do that.
Why haven't you reported probation since August the 10th? It's been over 3 weeks.
Excuse me?
Why haven't you been at the probation department since August the 10th? It's been over 3 weeks.
I've been trying to work and pay my fines off at municipal court, sir.
Well, that doesn't matter.
I understand that doesn't matter. I've not been trying to miss out on probation. I really haven't.
It doesn't matter whether you're trying or not. You are. That's the fact.
I understand.
The fact is you're not reporting and you're continuing to test positive.
At
At least the last couple of times it's only been for THC. But nonetheless, you're not reporting. Now, let me explain something to you, Mr. Collins. Community control means you do what I tell you.
Yes, sir.
And it means you report.
Yes,
and if you can't even report, then you're not going to make it.
I understand.
And, this is, and what you're just saying is, you just substituted your judgment for mine. And that's another big mistake, because you don't tell me why you decided not to do what I told you to do. You do it. You do it, period, end of story. There's no ifs, ands, or buts about that. So if you're told to report, you report.
Yes, sir.
And, if you don't report, then you're going to be back here in a pretty short order and probably going to end up in prison.
Yes, sir.
So, you need to understand that.
Yes, sir.
Well, I'm going to go ahead and place you on community control. You see it. But I can tell you right now that you better listen very carefully and do everything that you're told.
Yes, sir.
Because I'm not going to put up with a lot of stuff, especially when you start to be on that really lame excuse. So, it's the order of the court to be put under the supervision of the probation department and community control for a period of 3 years under these conditions. You obey all laws, all jurisdictions, conduct yourself in a law-abiding manner at all times. You report when and as directed. You're to be truthful in all statements you make to the probation department or any answers you give to them regarding questions they ask you about community control conditions. You're to keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility or attempt to communicate with anyone who is an inmate in those facilities without prior permission. You may not purchase, possess, use, have under control any firearm, ammunition, dangerous weapons, or weapons of any other type. Now, you may not purchase, possess, use, have under control any kind of controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance has effects similar to those of drugs of abuse, or any instrument, device, or thing may be used to administer them for parent administration, unless you have a lawful prescription, a copy of which you must provide to the probation department within 24 hours of receipt. You're to submit to drug testing when and as requested. You're not to purchase, possess, use, have under control any kind of alcoholic beverage, nor may be present places to be sold, being consumed, keeping otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any other person who has a criminal record, a member of a gang, or any other criminal group, or any person who has a past in the future, unless you commit a criminal offense or violate these conditions, unless approved in writing by a supervising officer that apply to any family members that might fall within that definition, unless you live with them immediately before this offense was committed. After the date of this order, you may not marry or establish cohabitation or common law marriage type of relationship with another person without written permission. Must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information and records so your ability to pay fees and costs can be reviewed. You're referred for any further evaluation or assessment from any other type of treatment beyond that, or therapy or programming beyond that ordered by the court. You'll submit to that. There's a recommendation for programming. You must enroll in and successfully complete that. Pay the court costs of this action within a reasonable period of time. Make payment arrangements with the clerk to do that. You'll be required to do 4 hours of community service at a rate of 20 hours per week for 20 consecutive weeks, unless you're employed at least 20 hours a week, you're a full-time student, or you have documentation from either a physician or a prior disability finding that you may not physically do that. You're to successfully complete the STAR program and aftercare that's recommended. The event availability date, I believe, is September the 15th. You're ordered to report to the jail on September the 12th by 4 p.m. because they require a 3-day detox program. Now, you shouldn't be using drugs, but most likely, I'm not a fool, you probably will. But if you get in more trouble or whatever, or if I get a report that you're testing positive, Goodwill have that warrant issued to get you in earlier. So, I want to make sure that you comply with this order. So, report to jail at 4 p.m. and bailiff's going to give you a copy of that. You better not be late for that. You better not miss, better not be late. And you'll end up getting a one-way ticket to the prison. Now, by being placed on community control, and by the way, successfully complete STAR means 100%. Doesn't mean 80%, doesn't mean 90%, doesn't mean 99%. You get kicked out the day before you're supposed to get graduated. And I've had that happen. You go, if that happens, you go to prison. Now, the only exception is if you have a bona fide medical condition that you did not create. So, for instance, I had one idiot that punched a concrete wall, broke his hand so he could get out on a medical permit. Well, you know what? Now we change that. It's, like I just said, you do it yourself. That's a violation because you didn't have a real medical condition. You were just looking for a way out so you could go use. Now, by being placed on community control, you're deemed and consented to a search without a warrant of your person, residence vehicles owned by you, or any other property placed under your control where you're found at any time, any officer of the probation department. I won't impose any fine nor any driving suspension. Now, no, actually, I have to do a 3-year driving suspension. That's it. So, it'd be 3 years, missing the day. And you're also ordered to pay court costs as a substantive order. If you fail to do that, in addition to being in violation of your conditions, the court could, the clerk could collect that in your means, including the late on bank accounts, wage earners, rather assets we have. That doesn't collect it, then upon completion, or then the court order you do the service, addition to what I've already ordered, and give you credit for each hour you work, and an hourly rate set by the court each hour you work, reduce your judgment by that amount until paid full. Now, the probation department feels that you're not complying with these conditions, they will file a written notice of that report for a copy upon you. You'll be entitled to have a hearing, be represented by an attorney. The outcome of that hearing is that you'll fail to comply. At that time, the court will revoke community control, sentence you to 36 months in prison, fine you $10,000. If that happens, once the prison sentence is complete, the adult control authority will put you under post-release control supervision for a period of 3 full years, because that's required by law. And if you violate any of those conditions during that period of time, then they have the right to return you to prison, even though you failed to comply with the order. Even though you served the entire term set in the court. For an additional period of up to 9 months for one violation, up to a cap or limit of half of your prison term for all violations. But if you commit a new felony, in addition, whatever sentence the judge in the new felony case would impose upon that judge also authorized sentence. In this case, for an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater, that occurs, that must be served consecutively as sentence in the new case. All right, is there anything further from counsel? All right, Mr. Collins, you go right down to the probation department and you report until the 12th, and they're correct. I get a notice from them you're not reporting. I'm going to issue a warrant to be picked up, held in jail until the 12th, until the 15th. If you do what I tell you, you report by 4 o'clock on the 12th to the jail.
Yes, sir.
All right, then you're going to get your signing notice here. We're going to call probation, tell them you're on the way down.
Yes, sir.
September 12th, Your Honor.
September 12th, 4 o'clock.
Yes, sir.
Right, and he puts on for Karen Adams. Oh, wait, who's her attorney?
Mr. Wagner.
Oh, okay. She's on Zoom. I don't know how that happened, but we go back to her. Ms. Adams, you'll need to put your video on. Your attorney's going back to jury room law. All probation tells me he should be there in the next 10 minutes. If he's not, I will know.
Pardon?
Ms. Adams, you need to activate your camera.
I don't know how to do that.
All right, down in the left-hand corner, there should be.
Oh, I see you. I see you. Do you see me?
It says start video or share video. Click on that.
Okay. Okay. It says Judge Rocky Cobb, and that's all it says.
Well, there's some place are you on a phone?
Yes, sir.
Should be somewhere on the phone, if you scroll down, there's a button that will say share video or start video, something of that nature. You just put yourself on mute, that's the wrong button. It's like in the shape of a movie camera with a, something like that.
Okay. Oh gosh.
If I may, Your Honor?
I'm trying, I don't see this.
Take off your hat. Sir, take off your hat. You're in courtroom.
Miss Adams, what kind of phone are you using?
I'm using an iPhone, and I don't see anything.
Okay, touch the screen where we're all at. There'll be a bar across the bottom. It should pop up when you touch the screen. It'll be the second icon on the left.
Okay, start video.
Alright, there
we go.
Alright. Case number 21 CR 117, State of Ohio versus Kara L. Adams. Ms. Adams is, this hearing is being conducted by Zoom, and you are Kara Adams, correct?
Yes, sir.
Alright, her attorney is James Wagner, he's appearing by Zoom as well, and then the state represented by Ms. Collins, prosecuting attorney. The defendant is charged with possession of heroin and aggravated possession of methamphetamine. This is a pretrial, first pretrial. Final pretrial set in 3 weeks of 22nd, and final pretrial is, the trial date is October 14th. Now, I see the state has provided discovery and particulars, and have you provided yours yet, Mr. Wagner?
I don't believe so, Your Honor. I'll have to the state by noon.
Okay. All right, and do you anticipate any pretrial motions?
Not from my initial inspection of the discovery, Your Honor.
And has been a written plea offer provided?
I have it. If my client can contact my office today so I can get her information or relay it.
All right, so you need to contact Mr. Wagner as soon as you get it done. Contact his office so you can give him a phone number so they can get in touch with you and get that information to you.
Okay, Your Honor.
All right, the next pretrial will also be by Zoom. And then the trial date will actually be in person if we get to that point. All right, stay in touch with your attorney, continue to report probation. All right, thank you.
Yes, sir. Thank you, Your Honor.
All right, I think that's it. About that.
That's all with Zoom for this morning, and Natasha Rhodes in person. Mr. Wagner.
Tasha Rhodes.
Tasha, right there, I'm my phone. I'm still on that side. Go do that.
Come around up here. Here, please.
Okay, case number 21 CR 102, State of Ohio versus Natasha J. Rhodes. Present for the state is Assistant Prosecutor King, present for the defendant's attorney James Wagner. And are you Natasha J. Rhodes?
Yes, sir.
Ms. Rhodes is charged with aggravated trafficking methamphetamine, aggravated possession of methamphetamine, both third-degree felonies, first pretrial. Final pretrial set for September 22nd, trial date set for October 12th. I see that the state provided discovery and, let's see, bill of particulars. Was there a request?
I don't request it all the time.
It was bill particulars, final August 24th.
Okay, yeah, there was a request, okay. It has been, oh, here it is, it's in the red dash. All right, now, you have not provided your discovery yet?
I'm not, sir.
All right, it'll be due by final pretrial.
Yes,
Do you
sir.
anticipate any pretrial motions?
No.
Has been a written plea offer provided?
Yes.
All right, is your client aware of it?
She is in all likelihood will be accepted. There's a residential treatment request. I'm assuming we can get her down to probation, maybe the assessment started with Ms. Thurgood or someone in that department.
All right, Ms. Rhodes, you have, internet access to your phone or?
Yeah.
All right, give your email and your, phone to the bailiff there. Next hearing, go back to doing it as soon as possible. And so, the next hearing will be by Zoom, whether it's a pretrial or the police agent before that. It'll be by Zoom. You'll get a notice from the, court. It'll be, HC online at, hccpc.org will be the address to see, so, they go into your junk mail, or filter file, make sure you check for that. All right, that'll be attended, just give that information back.
Thanks, sir. Go out, yes, stop, go out that way.
Are you, Herbert Phillips?
Yes, sir.
Or just have a seat up there then? Okay. So you can have one at the end, you can sit at the end. But you don't have an attorney with you.
You're Mr. Phillips?
Okay. Phillips. 21 CV 85.
On record, Your Honor.
This is case number 21 CV 85. Hyde County General Health District versus Herbert Phillips. Claims represented by Assistant Prosecutor King. And you are Herbert Phillips. Alright, this is a case in which the probation department, which are the health department, is seeking injunctive relief to evade land public nuisance of solid waste on premises owned by the defendant. We were here on the Z back on July 1st, and the hearing was continued for 60 days to see if the defendant was going to be able to get things cleaned up to the satisfaction of the department. So, Mr. King, where we stand on that?
That's what I was just discussing with Mr. Webb here from the health department. He's indicated that the property has been cleaned up. However, it's been cleaned up by loading all of the debris, junk, trash, whatever, into 2 pickup trucks. And those 2 pickup trucks have been parked on an adjacent parcel that is not owned by Mr. Phillips.
On property,
Correct. So that's where we're at.
Mr. Phelps, I had you got that stuff all the way, and then the property is supposed to.
I got to take it to the dump.
I'm sorry?
I'm taking it to the dump.
Okay, we'll have you take it to the dump.
Get it all gathered up. I got it all.
Well, it sounds like it is, but right now you're apparently trespassing on someone else's property. But, that's not really fixed the problem. All you've done is move the debris to next door, and that's not really, appropriate. When are you gonna be able to get to the dump?
I can get there probably before Monday.
By Monday, all right. I'll put on there by Monday. And, contact the health department, and confirm that the trucks are gone, and then, provide them get a receipt or something from the dump, the disposal facility where you take your stuff, show them that you did that, and then, my understanding is that the dismissal case, you'll have to pay the court costs, but, you won't be under any kind of findings, that are injunctive relief, so you need to get this done, so, so we don't have to issue an order to make you do it, you, subject to being held in contempt. All right? And you'll see them on the way out.
I talked to that same guy. I talked to him yesterday. He said, more about it.
you guys had that one time. But once you go being alcohol, who's supposed to put all that? Is it your law on the market? And so probably yeah, I think that's back to Lutheran. Yeah, that's pretty much all it was. Okay. Thanks, maybe.
I just want to play with CBA too. Just to help our first names.
That's a 10, or
Oh, it's
11 a.m.
Okay, our next case is at 11, so, okay, great.
Please rise.
So, I want to do is next one. She told me that, yeah, he would have been at work. Yeah, information, I'm not giving you. This you probably have seen so this one is right?
There's where my handcuffs went to.
They're down there in that
Clean that
blow
box.
rag box. Yeah. Trying to get the rest of the docket in for this afternoon.
You two working everything?
Yeah, it's still on. Come think of it. Kill the audio.
Loudoun County General Health District versus Sean Haynes and, it says Guthrie Wendland, but I believe it's supposed to be Wendland Guthrie. And I'll go ahead and change that. Alright, this is an action filed for abatement of public nuisance due to accumulation of solid waste prohibited by law. Defendants were cities. Request service, ordinary mail, leave. The personal service mail, Wendland Guthrie on line 15. Actually, line 16. And return of service of Mr. Haynes, July 16th, and he did not live there. And another one return indicating he's an APA violator at large. Alright, there's a request for certified mail. July 15th. Ms. Guthrie was returned unclaimed in office, but she already served personally. Mr. Haynes was returned unserved on this. Alright, and then there's a request for ordinary mail service. Mr. Haynes, I think you have service on Mr. Haynes. Because your prior return on personal service said he did live at the address, and the certified mail went to the address that he knew he wasn't living at, so that's not valid. Ordinary mail service is not valid.
I don't think anybody knows where Mr. Haynes is at.
Well, I'm sure of that. Miss Guthrie is apparently at the property.
No, she lives at another address. I have that.
Well, she's been served, but we don't have service on Mr. Haynes yet. I don't know if you want to do publication or you want to proceed. Property's in both names.
Right.
Has there been any contact with Miss Guthrie?
Yes.
And is she doing anything about the property?
No.
No. I'll continue this and give you an opportunity to get service on Mr. Haynes or publication or however you want to do it. Looks like Mr. Guthrie's going to be the one that's going to be pulled back. Mr. Haynes is at large. We sent her a, what's interesting, we sent her a notice in P.O. Box 2 in Newtonville. Return unclaimed. I don't know how you can return regular mail unclaimed. That's what it says here. That was on July 22nd. Received. Alright, we'll continue this to get service on Sean Haynes. And then, as soon as my publication, that's what we're going to do. Because in order to get a title recognition, you're going to have to have service. And then you can decide whether or not you want to proceed against Ms. got her alone, she is joint and severally liable. But let's see if we can get service on him first.
Yeah.
Alright, I'll give you 30 days to obtain service or start publication. And we set this in about 60 days. Anything else?
There you go.
Alright, thank you.
Please rise.
Entries for judge from that sentencing this morning.
Okay. And you don't have any plea agreements at this point?
At this point, no.
Okay.
You know how